We have heard about the ambivalences of memorialization, almost memory as a double-edged sword. It might lead to social recovery, peace, reconciliation, but it can also deepen injustice, reinforce victimization, bolster division. We have today, this afternoon, an extraordinary lineup of experts whose scholarship and also whose direct experience in Rwanda will help us shed light on the complex issues of dealing with the legacies of mass violence in Rwanda, and it will also help us to see what lessons we can learn from the Rwandan experience for other cases, for other transitional cases. I would like to briefly introduce our distinguished panelists. Professor Gordon will be the first speaker. He is director of the University of North Dakota Center for Human Rights and Genocide Studies. He teaches criminal law, comparative law, international law, and international human rights law. Professor Gordon worked with the Office of the Prosecutor for the International Criminal Tribunal for Rwanda, where he served as legal officer and deputy team leader for the landmark media cases, the first international post-Nuremberg prosecutions of radio and print media executives for incitement to genocide. For this work, Professor Gordon received a commendation from Attorney General Janet Reno for service to the United States and international justice. Our second speaker, Holly Nisset-Brehm, will present her work together with Chris Eugen. Holly Nisset is a sociology PhD candidate at the University of Minnesota. Her dissertation examines the factors that influence the onset of genocidal violence globally, as well as regional and temporal variation within genocidal violence in Rwanda, Bosnia-Herzegovina, and Sudan. In the fall, she will join the faculty at Ohio State University. Congratulations, Holly. Chris Eugen is my esteemed colleague at the sociology department here at the University of Minnesota. He is Distinguished McKnight Professor of Sociology. He studies criminology, law, and deviance, firm in the beliefs that good science can light the way to a more just and peaceful world. His current projects involve, among other topics, comparative study of re-entry from different types of institutions, crime and punishment in genocide, and the health effects of incarceration. Dan Wilderson is professor of communication studies at St. Cloud State University and the director of the Center for Holocaust and Genocide Education at St. Cloud State University. He, as professor of rhetoric, he has taught courses in ethics, argumentation, and persuasion in the Communication Studies Department, as well as expository writing and Holocaust literature for the Department of English. He served as the founding content consultant for Tolerance in Motion, a mobile museum project of the Jewish Community Relations Council of Minnesota and the Dakotas, and his main research interest is in the ethical implications of discourse, specifically in the areas of rhetorical epistemology and the educational representations of the Holocaust and the genocide in Rwanda. Nicole Fox is a PhD candidate in the sociology department at Brandeis University. Her dissertation is titled Moving Beyond Violence, Memory and Nation in Post-Genocide Rwanda. And it's a work that focuses on the role of memorials in the transitional process from mass violence to post-genocide in present-day Rwanda. She will be joining the sociology faculty at the University of New Hampshire in the fall. Also, congratulations. So this is also the order of presentations. Each speaker will have 10 minutes for his remarks, and so we'll have also time for questions from the audience. You will have the opportunity to write your question on a note card, and then I will pass it on to our presenters. I would like to thank all our presenters for being here with us today, and let us now turn to the first presentation of Greg Gordon. Thank you very much.
I want to thank the University of Minnesota and all of the programs and departments that are sponsoring this, I think, extremely important conference where I think both on a national and a regional level, it falls on us to raise awareness about what happened and about what could happen again if we're not careful. And my piece on this is the role of the International Criminal Tribunal for Rwanda. Dr. Baer talked about how there are different pieces to the puzzle, and my contention is that all of them, it's not a zero-sum game. All of them are necessary and important in terms of making sure that justice is rendered and that this sort of thing doesn't happen again. So I'm going to focus on the ICTR's role, and what I'm going to do is, assuming this moves forward, there we go. I'm going to talk a little bit about the background and the results, as well as the current status of the International Criminal Tribunal for Rwanda. I'm not going to assume that you know a lot about it. I'm going to assume that it will require a little bit of explanation where it fits into this puzzle. And then I'm going to talk about its accomplishments, and I'll give you a sense of the numbers, as well as the sorts of defendants and cases that have come through the tribunal. I'll talk, frankly, about some of the criticisms that have been leveled against it, and I'll try to put those criticisms into perspective, and then I'll conclude with some thoughts about all that. So, as far as the background goes, it falls on me as well to be the first presenter for this panel, and I'm not going to assume that you know everything there is to know about the Rwandan genocide. I'll talk a little bit about it. The very basic thing to know is that nearly 1 million people in 100 days were slaughtered, and this, of course, was from April to July of 1994. And the Tutsi population of Rwanda bore the brunt, moderate Hutus as well. But the bottom line is that all of Rwandan society was affected, and the judicial sector, including personnel and infrastructure, was decimated. And that's a very important point, I think, to make as I start to talk about the ICTR and the role that the ICTR played, especially in the immediate aftermath of the genocide, which is what this panel is about. Not surprisingly, in light of this, the new Rwandan government asked for the tribunal to be created. It then had a change of heart when it realized that the seat was not going to be in Kigali, but rather in Arusha, Tanzania, and that there was a limited temporal jurisdiction to just 1994, and that the tribunal would be sharing an appellate chamber with the ICTY in The Hague, and that there would be no death penalty. When these things became apparent, the Rwandan government was not happy with the arrangement, but by then the ship had sailed, and the ICTR was created in November of 1994 pursuant to UN Security Council Resolution 955, and it was set up to prosecute the persons most responsible for genocide and other international humanitarian law violations committed in Rwanda or by Rwandan citizens in neighbor states between the 1st of January and the 31st of December 1994. And its seat was to be, as I mentioned a moment ago, in Arusha, Tanzania, and it would have jurisdiction with respect to 3 core crimes: genocide, crimes against humanity, and violations of Article 3 common to the Geneva Convention, as well as Geneva Convention Additional Protocol 2. All right, so that's the basic background. That's what the tribunal was set up to do. Its results, now that it's been around for almost 20 years, I think are worth talking about. So it's indicted 93 persons, including high-ranking military and government officials, politicians, businessmen, as well as religious, militia, and media leaders. So really the entire spectrum of Rwandan society that could have been involved in the genocide has gone through the justice process at the ICTR. And as a result of that, 61 individuals have been sentenced. I'm about to tell you how many people have gone to trial. When I specify the number that have been sentenced, obviously what that implies is that a certain number pled guilty and they didn't go to trial. But those who didn't include 75 individuals in 55 cases that went to trial, and 49 of those individuals have been convicted, 14 have been acquitted, and 12 are awaiting the outcome of their appeals. So that's pretty much where things stand in terms of the numbers and the sorts of persons who have been brought to justice by the ICTR. Let me talk a little bit about what's happening now with the tribunal. And there are three things that I think bear mentioning here in terms of what the tribunal is doing. It's judicial activity, and then what is now called the Mechanism for International Criminal Tribunals, or MICT, and then its legacy and outreach work. With respect to its judicial activity, obviously it's been winding down. It delivered its last trial judgment on December 20th, 2012, and all that remains as far as judicial activity is concerned would be the work that the appellate chambers are doing with respect to those appeals that I talked about a minute ago. Now, what's really interesting is this Mechanism for International Criminal Tribunals. This was set up in 2012, in July 2012, and what it's going to do primarily, now that the judicial activity is winding down, it's going to, first and most important, track the three fugitives who have remained, if you will, within the jurisdiction of the ICTR. In other words, the ICTR has not turned over the cases to Rwandan domestic authorities for these three individuals, and they would be Felicien Kabuga, Prote Mparianya, and Augustin Bizimana. Felicien Kabuga is of particular interest to me because he was one of the suspects that we were looking at in connection with the media case that I worked on, because he was the financier of Radio Mil Colline, and he was also a financier in general of the effort to arm the militias to prepare for the genocide. So the ICTR will remain seized of those cases. It will also handle residual matters such as contempt or perjury proceedings that come out of whatever remaining judicial activity is left, including the potential trial of the three suspects I just talked about. I should also point out that the International Criminal Tribunal for former Yugoslavia is part of this, and it has its own office, if you will, under the MICT, just as the ICTR does in Arusha. The other part is the legacy and outreach work, and the ICTR has established an information and documentation center that also has 10 provincial branches that are spread throughout the country. It also has an outreach team that conducts awareness raising exhibitions, for example, workshops and judicial training. So clearly the ICTR has transitioned into doing more than just processing cases and doing sort of, if you will, traditional criminal prosecutions. Let me talk about what I consider to be the accomplishments of the tribunal. First of all, I think we can look at the tribunal as being responsible for beginning the justice enterprise with respect to the aftermath of the Rwandan genocide. It's also been responsible on an international level for developing some very important precedents in international criminal law. It's established important capacity building within Rwanda and the Great Lakes region, and it's helped facilitate transfer of cases to Rwanda. So let me unpack each of these. It's also, of course, preserved memories and precedents, and the center that I talked about a moment ago is an instrumental part of that. As far as beginning the justice enterprise, remember, we're talking about the immediate aftermath of the genocide. The ICTR here is really crucial because it started to do investigations and bring fugitives to justice while the Rwandans were simply dealing with the devastation and the void that came in the immediate wake of the genocide. They were ill prepared, as I think I mentioned earlier, when they asked that the Security Council form the tribunal to do any of this themselves right after the genocide. And I think it's worth mentioning that in light of the scale and scope of these crimes, right, 1 million people in 100 days, that really the ICTR was representing humanity as a whole. So if you talk about local justice, if you talk about transitional justice, I get what you're saying, but I think if you talk about crimes of this scale and this magnitude, that actually humanity is your plaintiff at the bar, and that it's good to have an international tribunal that represents humanity, and I think the ICTR has done that. And what it's done is it's brought to justice the architects and the leaders of the genocide, including Prime Minister Jean Kambanda of the Rump government. And he was the first head of state convicted since Nuremberg of atrocity crimes. So very important historical, sort of international, large-scale work that was being done by the ICTR. The other thing that's near and dear to my heart as a law professor, of course, is developing international criminal law jurisprudence. And this was, and it's often referred to as the Genocide Tribunal. This is the first really international tribunal to deal with the crime of genocide, because if you look at the Nuremberg tribunals, right, or in particular the International Military Tribunal that tried the major Nazi war criminals from 45 to 46, all that was before the Genocide Convention was adopted in 1948. So you didn't have the sort of cases that would have genocide as a crime until you got to the International Criminal Tribunal for Rwanda. And so it's the first international tribunal to flesh out the elements of genocide. It's the first international tribunal to define rape in international criminal law and recognize it as a means of perpetrating genocide. Extremely important precedents in my view. And then for the subject that's near and dear to my heart, as Dr. Baer explained, given the fact that I worked on the media case, and I can tell you that my scholarship is focused on hate speech and atrocity. That's what I do in my research. The ICTR has been absolutely instrumental in forming a body of jurisprudence with respect to that subject. It formulated the elements for direct and public incitement to commit genocide. It established that hate speech, not directly calling for violence, can be the basis for charging persecution as a crime against humanity. Now, the ICTY has come out on the other side of that issue, and it's going to be interesting to see how that's resolved. But I think the ICTR had the right idea about this area of the law, and I hope that ultimately that influences where the law goes in the future. The tribunal has also helped facilitate the transfer of cases to Rwanda, to the Rwanda domestic jurisdiction, which is now in a position to do what it couldn't do in the immediate aftermath of the genocide. So recently, the ICTR has transferred several cases to Rwanda domestic courts. And in fact, in the period leading up to this, I think it's very important to mention that the ICTR helped persuade Rwanda to improve due process guarantees and judicial independence, as well as abolish the death penalty as an incentive to facilitate transfers. So that's strengthened, in my opinion, the Rwandan judicial system, and has also helped persuade other countries that have genocide fugitives, countries in Europe, for example, or North America, to feel comfortable transferring cases to Rwanda. I think this is a very important part of the puzzle of getting justice after the genocide. So this is another accomplishment. Also, capacity building and memory. The ICTR has forged partnerships with national authorities in Rwanda, the Great Lakes region, and across the continent for the purpose of fostering mutual assistance and international cooperation to prosecute crimes of an international nature and thereby promote accountability, justice, and due process. The Information and Documentation Center, or Umusanzu, that I talked about a little while ago, and those 10 provincial information centers that are located throughout Rwanda have already allowed approximately 65,000 persons to get access to the tribunal's extensive collection of genocide-related records, briefing materials, training resources, library services, and video screenings. It's quite a complete collection. Now, the criticisms that have been leveled against it are that it's slow and expensive, it's obtained meager results, it's had some acquittals that have been troubling lately, and that it's accused of victor's justice. with respect to it being slow and expensive, the critics will say it's been nearly 20 years since the ICTR was established, and it's still not finished, while spending over $1 billion during that time. And I think it's worth noting that it's difficult to start a court from scratch and prosecute the architects and leaders, because what that means is the investigations and the adjudications are going to be about everything that happened underneath those leaders, which means you have to establish everything that happened. It's a tremendous enterprise, and they were starting from scratch. So I was there at the beginning. I know how difficult it was. And we've learned invaluable lessons as a result of the ICTR because of this. The other criticism is that it's gotten meager results. So people will look superficially at the numbers and say, look, in 20 years, only about 50 people have been convicted. What is that? That's nothing. And my response would be that the ICTR was meant to prosecute the big fish, and it has succeeded in that endeavor. And that when you look at those architects and those leaders, again, that covers everything that happened. The acquittals, recently there was the acquittal of Justin Mugenzi and Prosper Mugiraneza, as well as an earlier acquittal such as that of Prote Ziggy Ranyarazo, and that demonstrates that the ICTR has not effectively brought genocidaires to justice. But I think it's worth noting that the acquittals show that this is not a rubber stamp tribunal. This is not a kangaroo court. But still, it's worth pointing out that the ICTR has a 20% acquittal rate. That compares to about 27% in the Rwandan domestic courts and about 35% in Gacaca courts. So you have to put that in perspective. And then, of course, we're here that it's victor's justice, and this has become a very controversial subject, but the critics say the ICTR has prosecuted only extremist Hutus connected with the genocide perpetrated against the Tutsis. It has not prosecuted crimes committed by the RPF. And I think this is true, but as a practical matter, think about it. The ICTR needed the cooperation of the Rwandan government to fulfill its mandate, and it would not have gotten it had the RPF officials been prosecuted. So the question comes up, do you cut off the prosecution of genocidaires that you could otherwise prosecute versus prosecuting the crimes that were committed by the RPF, which were not genocide? It's not a good situation, and I don't think any of these crimes should go unpunished, but that's what the ICTR was faced with. And I think it also shows, and it partially answers another criticism of the ICTR, that it should have been based in Kigali. That's crazy. I mean, look at the pressure that's put on as it is with the investigations. And note, there have been domestic prosecutions of the RPF officials, but these have been criticized as whitewashed justice. So in conclusion, I think it's safe to say that the ICTR has certainly not been perfect. Of course, it's also been criticized for things like not having victims as parties or allowing for reparations, but it has been an important component of the justice process that has taught us many valuable lessons, for example, with respect to victim participation and reparations and all the other things. And I think the true test of the ICTR and all the other justice mechanisms used to deal with the Rwandan genocide will be whether the culture of impunity has ended in Rwanda and the region so that no mass atrocities occur in that country or in the region in the future, and the jury remains out on that. I hope it's true. We shall see. Thank you very much.
Thank you, Professor Gordon, for a comprehensive introduction. Our next presenters are Holly Neiseth-Brem and Chris Ubben.
My role today here is to address some of the broader social imperative to do justice, continuing on the discussion of the ICTR, but really focusing on the remarkable expression of this imperative in the Gacaca courts. As a recent visitor to Rwanda, in the morning, we would often be confronting the acts of the perpetrators, the crimes committed, and genocide is certainly a crime. And then coming face to face with those perpetrators themselves later on, whether they're in prisons or on their way to the communities through community service and what's called TIJ camps, which Holly will discuss we'll discuss soon. Now, given the scale of the genocide, neither impunity nor vengeance were viable social responses. And given this devastated legal infrastructure, the numbers affected, it was crucial that justice be done in local communities. Our question today is, how has Rwanda, whose criminal justice system was destroyed by the genocide, attempted to bring the massive number of perpetrators to justice? We'll be describing our data, almost 2 million Gacaca court cases, and then we'll do we have the roadmap, Holly?
Yeah.
Yeah. Then we'll first talk about those courts, then we'll describe the perpetrators, and coming from a career study in crime and punishment, we'll spend a bit of time on the perpetrators themselves before moving into the sanctions that were given by the courts, and finally conclude with a few remarks on the implications for transitional justice. Holly?
All right. So first to tell you just a little bit about the Gacaca courts. Gacaca courts actually date back to before Rwanda was colonized. Gacaca means grass in Kinyarwanda, and as this name implies, traditional hearings before colonization were generally held outside in schools or in open marketplaces. In an ideal setting, a defendant in this type of tribunal would confess their crimes, ask for forgiveness, provide some form of restitution, and then provide food and drink for everyone involved as a symbol of reconciliation. This traditional method of dispute resolution bears close correspondence to many principles of restorative justice, and beginning in the 1940s, it actually became sanctioned as a way to deal with common crimes. Yet it's important to note that it did not deal with murder or other crimes deemed more serious. In the aftermath of the genocide, as has been discussed, Rwandan leaders were faced with how to come to terms with the fact that more than 1 million people participated in the crimes. And while there was the ICTR, they also had to think about how to rebuild society. So again, they turned to the Gacaca courts and they decided to modify them, really heavily modify them, as a way to address these crimes of genocide. And I should note, we are not taking too much time to talk about the criticisms, but these have been heavily criticized, which we'll be happy to talk about. But for example, one criticism would be the shift from a more local level informal court to a very formal court, often with ties to the state. So what were these courts? As you'll see a picture up here, this is what the courts looked like, and they were set up at local levels throughout the country. So as Dr. Gasanabo mentioned this morning, there were more than 12,000 courts. As was also mentioned this morning, there were not enough lawyers and judges to staff these courts, and beyond this, they were meant to be community courts. So lay people from the communities were elected as the judges. You did not need legal training to be a judge. Instead, you had to be 21 years old, and you had to display a commitment to justice. These judges then underwent a small period of training, and then the Gacaca phase actually started a pilot phase in June 2002. The pilot phase was really a process of learning, and after several years, in March 2005, the judgment phase of the courts began. Those then ran until June 2012, when the courts closed, 10 years after the pilot phase first started. So as Chris mentioned, our two goals today are to give you a snapshot both of who went through these courts and a snapshot of the sanctions that they received. So because of this, we're relying on official court data. And as been mentioned several times, there were about 1.96 million trials. So this is a very large database. To be clear, the courts are also archiving specifically what happened during the trials, and there are millions of documents and hundreds of thousands of boxes, as you can see in the picture here, that are currently being archived in Kigali. And this process will take years, as Dr. Gasanabo knows very well, and this will be a very important archive in the future. Right now, however, to begin studying the courts and looking at their outcomes, we have access, through collaboration with the Rwandan Commission for the Fight Against Genocide, to abbreviated court records that Gacaca employees kept with key points of data about the courts. So these court records are importantly categorized in three key categories, and this is really a key aspect of the Gacaca courts. So every case was given a category, and these categories are really based on severity. So category 1 was really seen as the most severe category, and these were people who planned the genocide, supervised the genocide, people who used positions of power to commit genocide, but also to incite genocide, as well as rape and sexual torture were seen as very severe cases and put in this category. Category 2, then, is really other crimes against people, so murder, intent to murder, and torture. And category 3 is crimes against property, so this is generally looting or destroying people's homes and crimes of this nature. As you can see from the numbers on this slide, the vast majority of the cases were in category 3. So this, again, crimes against property, you see 67%. 30% were in category 2, crimes against people such as murder, and then 3% were in category 1. It's important to note, though, while it's just 3%, because of the large number, this is over 60,000 cases. So as we mentioned, we can use these data to better understand a few things, and one of this is to understand who went through the court system. And as we're understanding this, we can also begin to understand who participated in the genocide. To be clear, not everyone who participated was tried by the courts, but to date, these are the best data that exist. So we wanted to show you a few figures to get a small snapshot of who was tried by the courts and who participated in the violence. And the first here you see is a figure of the percentage of people who participated and who were tried by age. So a few things to note. First, you see that the average age of people tried by the courts is 30 to 34, and this is also the average age of those found guilty. You also see that there are a few people who were youth who participated, and also a few people who were elderly. And you also see that it's the same age for all three of the categories. Criminologists call this figure an age crime curve. And I see a few of my students from this summer here who will remember this from our class, and we spoke a little bit about criminological theories looking into why people participate in crime, often starting with really basic identifiers like age or like sex. And criminologists have long been looking at hate crimes, murder, gang-related murder, white crimes, or white-collar crimes like embezzlement. Many different forms of crimes often tend to have a very similar age crime curve, which I'm displaying here. And again, like the age crime curve from Rwanda, you'll see that there are a few youth and also a few elderly, but you'll also see that the average age here is about 19 to 20. So one of the things that we won't have time to get into now, but one of the things we're interested in looking at is why this curve looks different and in many ways older in Rwanda. To give you one other snapshot of perpetrators, or at least people who went through the court system, this shows the number of women who were tried. And as was mentioned earlier, there were also women perpetrators, and 9% were tried by the Gacaca courts. You will notice, however, that there's a higher percentage of people who were women who were participating in looting than in crimes against people, which again is very consistent with criminological research. So we can also use these data to better understand the sanctions that were given by the courts. And 86% of the trials that went through the courts resulted in a guilty verdict. But these sanctions really varied by the severity of the three categories. So up here you see different sanctions that were given for category 3, which were the crimes against property. So you'll see up here first fines, and fines were by far the most common sanction. The median fine was about 7,100 Rwandan francs, and this in current US dollars is about $11. And many of the fines were really between $2 and $39. It's also important to note that the fines were meant to be paid to the victims or to their families. You'll see other examples up here, though, that there were many other types of sanctions at this level. So perpetrators found guilty could be asked to return or pay back goods that they had stolen. They could also enter into agreement with the victim, and this would need to be initiated by the perpetrator and would really be a negotiated agreement about what the sanction would be. Also, you see up here exemption, and this is when the perpetrator would ask for forgiveness, often recognize the crime, but not have to pay a fine, often due to monetary issues. To look at this visually again here, you see fines represented 87%. And you'll see the other different sanctions at this level listed. We won't go through all of them, but we'd be happy to talk about them later. Category 1 and 2 then, again, these were seen as more serious, crimes against people, murder, and also different category 1 crimes that were seen as the most serious. And because they were seen as more serious, often the sanctions involved prison. So you'll see in this figure that 91% of crimes in these two levels ended with a sanction involving some type of prison, and in addition, 5% were sentenced to life in prison. If we look at this by year, however, we do see that there was a wide variety in the sentences. So some people were only sentenced several months. Others were sentenced up to 30 years, and again, there's the category of life. And the vast majority were sentenced 10 to 15 years. And Chris will now take over.
Yeah, to get a bit of a perspective on this as a criminologist, I think we sometimes understate the degree of societal transformation that's occurred in Rwanda. And just as a reference point, many know here that the United States is a world leader in incarceration, incarcerating a greater rate of its citizens than any other nation. We plotted the rate of state prison incarceration in the United States versus the rate of incarceration in Rwanda in the post-genocide years. Now, some of these numbers are difficult to obtain with accuracy. We tried to play it down the middle and get as a conservative estimate of the incarceration rate. You can see that Rwanda has undergone a tremendous social transformation in terms of reintegrating very large numbers of former perpetrators. And this, I think, has been accomplished with relatively little fanfare. There's part of the way that this was accomplished is through the use of community service, what we would consider community service. About 29% in our data set were given community service, at which point they would be eligible to serve half their time outside of an institution. I mentioned there's a justice imperative. There's also an institutional imperative. One of the prisons we visited, in 1930 prison in Kigali, had held as many as 60,000 people in the immediate aftermath of the genocide. Now that's down to approximately 3,000, and I think approximately 300 former perpetrators were incarcerated there on the day we visited. So there has been a tremendous change here. And part of this, and I think what's particularly telling for scholars of restorative justice or of transitional justice, is that many of the activities of these groups are quite meaningful. Building schools, preparing homes for the survivors, that individuals often find meaning that far beyond the sort of restorative justice approaches that have been tried in many other nations. We visited a camp where there were about 190 men and a dozen women or so who described their activities and very much looked forward to rejoining those communities. So let me sum up relatively quickly. That Gacaca is partly, in our view, about dualisms. There is a formal and an informal piece to the process. There is a community-based orientation as well as a state-driven orientation. It is a traditional and a contemporary practice. And the sanctions blend, as you saw, severity-graded, punitive and restorative responses. Now, this duality certainly opens Gacaca up to criticism, and in particular, Gacaca cannot meet the standards of either the strict liberal legal model or a traditional restorative practice. But that said, it's been effective in processing and doing justice in an astounding number of cases and meeting, in part, Rwanda's societal imperative to do justice. So I think going forward, one of the big questions is to what extent can the rest of the world learn from Rwanda's experience with Gacaca and in other cases of mass atrocity and then far beyond. Thank you very much.
Thank you. Let us now move to Dan Wilderson.
First of all, I would like to thank you, Alejandro, for inviting me to be on this panel and also giving the Center for Holocaust and Genocide Education at St. Cloud State an opportunity to co-sponsor this conference. It's a very important conference to have, although I think there are things that we continually face as we evaluate, analyze everything that happened there from this perspective here. And I think it's always important to keep that in mind as we qualify what we say. Going over there often is not enough, and I'm not in any way critiquing any of my colleagues here. This is a problem that I think everybody needs to get their minds around, so it's important that we continue this conversation. What follows for me is a series of caveats and qualifiers, I've given a few already, that pick up on some of the implications and allusions that some of things that have fallen out from the contested narratives in particular, and perspectives about who will be memorialized and what the political trajectory of the country is. I'm a somewhat latecomer to the study of Rwanda, confessing that, so I don't claim to be an expert in this area. Most of my work has been done in the Holocaust, and it's difficult for me not to do a comparative reading or an analogical reading of the two, recognizing, of course, that they're quite different, and yet at the same time it's maddening how similar sometimes they seem. I visited Rwanda twice. The second time was with my daughter, who's in the audience today. It was a moving experience for both of us, I think, because we spoke with 11 women about their experience going through the Gacaca process, and the conclusions that we drew from those interviews was that the Gacaca process for them, although it yielded no restorative results, was still a valuable thing for them in their communities and preserving their identity and helping them move forward. So all the criticisms that can be lodged at Gacaca, I think, need to be taken into perspective there too, by continuing the interview with people who have gone through that process. So the work that you guys are doing is really critical and very complementary to what's happening at the level of the ICTR as well. I presented at one conference about the genocide where several individuals wanted to even the score of indictment for atrocities by disrupting sessions, screaming liar at the survivors, telling their stories, which even happened at the University of Minnesota several years ago in a statement that was made to me by a person who was a Rwandan survivor. She was giving her testimony for the first time here at a conference, and she was threatening with being censored, actually, from even telling her story. So I think we've come a long way. The other thing that happened at the conference I was at was that people were carrying posters alleging that the current governing administration in Rwanda was a group of bloodthirsty killers. Certainly you've heard this before. And I was reminded of the 1961 Eichmann trial, some 16 years after the end of World War II. The context and arrangement of issues were quite different, of course, but the rawness of emotions were similar. I have appreciated the gentleness and respect that has characterized our conversation so far in this conference. I think that's really critical. I was in South Africa a couple years ago during Israeli Apartheid Week, and there was a very large crowd of people there to hear a person representing the Israeli perspective and one representing the Palestinian perspective. And the person representing the Israeli perspective could not even be heard because of everyone screaming and yelling and throwing things at him. So while I admit to the complex and diverse perspectives regarding the post-genocide situation for Rwanda, I found the strategies and tactics of deniers, diffusers, and negationists to be remarkably similar to those who engaged the Holocaust. For them, the internet has provided a facile tool. I was at the 18th commemoration in Kigali, just about ready to give a paper, and I got an email from a guy named Bradley Smith, who was a notorious Holocaust denier, saying, "Thank you for letting me once again publish my advertisement in your school newspaper." The role of technology and the creation of a digital universe of meaning related to genocide is perhaps the subject for a future conference. We will need to address that. But my purpose in exploring this topic of the Janus head of collective identity, that which looks at the past and the future on the occasion of the 20th anniversary, is twofold: to try to understand the nature of Rwanda's predicament and to try to figure out what and how not to teach my students about Rwanda. I don't think I have too many illusions about the limitations of my perspective. My effort here is to think into the situation in a way that engages this conference as a conversation. Because my topic deals with identity and civic engagement, I have found the work of Hannah Arendt, especially The Human Condition, The Life of the Mind, and Eichmann in Jerusalem, A Report on the Banality of Evil, to be useful, at least for isolating and describing a couple pivotal issues. I don't mean to suggest that I'm going to use her as a deductive cookie cutter, rather as I wrote my dissertation on her work, and so I just can't seem to get away from it. But for me, as I was reading this into changing fields, because when I became the director in 2009 at St. Cloud State Center, nothing had been done since its beginning in 1989 in the area of genocide that really showed up anywhere. It was really all about the Holocaust, and so I began to try to create some programming around that and was drawn into the Rwandan situation. And so in reading these things, some of Hannah Arendt's ideas have really come alive. But first, so there are three things I'm going to say, two of these ideas of Hannah Arendt's that I'm going to use to talk about this, but I wanted to get back to the thread that was referenced this morning about Ndi Umyu Rwanda. And I know that I'm not saying that correctly. I practiced a lot, but anyway, in English it is I am Rwandan, or maybe I am a Rwandan. This program was started in 2013 by a young artist by the name of Bamporinki Edouard. Allegedly, there are several sources that say this. Its origin is also associated with the Youth Connect Dialogue, an initiative of Rwandan youth, the Imbuto Foundation, Art for Peace, and the National Unity and Reconciliation Commission, which aimed at looking beyond what divides Rwandans to have a nation that is built on truth and trust. The concept is based on 4 pillars: history, testimony, forgiveness, and healing. Or in the words of the Minister of Agriculture and Animal Resources, Dr. Agnes Kalibata, we need to come clean by telling each other the truth about our history. Let's come together so that we can move ahead. I mention her because President Kagame has taken this youth initiative and made it something that applies now to the entire nation, and a lot of the government offices are involved in that beginning work. It has become controversial for many reasons. It inaccurately, these are some of the charges, it inaccurately represents a genocide in which both Hutus and Tutsis were victims by formulating a deductive system in which the main premise has all Hutus are perpetrators and all Tutsis are victims. Because the implementation of Ndi Umyu Rwanda is now being expanded to everyone in Rwanda, but especially applied in all government offices at the urging of President Kagame, it cannot possibly be a genuine experience of the people. Others argue that it employs collective guilt by leveraging expressions of representational apology. For example, in the name of the Hutu family, I apologize to the wider Tutsi family because of the genocide perpetrated against them and committed by my fellow Hutus. This was stated on the radio by a member of the East African Legislative Assembly. Although I do not intend to address any of these criticisms, I in no way mean to imply or suggest that Tutsis were not the main victim group in the genocide. I think they were. I do want to say a word about representational apologies. This problem of representation, specifically speaking for others, conjures up the same kind of issues raised in Simon Wiesenthal's The Sunflower. And it's the reason why the Mengele twin Eva Kor, who went to Auschwitz and read a document before the camera in which she announces that she has forgiven Dr. Mengele, is despised by some and adored by many. When she spoke at SDSU last year in the Ritchie Auditorium, it was overflowing because people were so enamored with her capacity to forgive. I know that's flipping this around, but we are in this domain of accountability, and there are other criticisms. But my main concern arises when the context of education, specifically education of the post-genocide generation, occurs. And not to exclude anyone, but we could just say that anyone born after July 15, 1994 in Rwanda, that's the group, as director of the Women in Public Policy program at Kennedy School, Swanee Hunt says, for whom that genocide is a story and not a memory. This puts students in Rwanda after that date in the same category as my students, in a way. And one of the issues there is that I can offer a class and we can talk about American Indians who used to hunt the land on which our school was built. Is it their history? Whose history is this now? Or is it just story? And these are some questions that really need to be addressed. Two concepts of Hannah Arendt. The first one is natality, or birth. And with it, the capacity to quite literally start something new. Studies and stories of child soldiers abound, and we see now in Syria that thousands of children are being used and abused in every way possible by all sides of the conflict: sex objects, combatants, torture opportunities, and human shields. And I offer this observation by way of a comparison. It's a rather extreme example, but while children inherit a genetic code from their ancestors, they don't inherit a family legacy. That is something that is socially and symbolically constructed. And one of the uses to which children are often put is to carry on that family legacy, culture legacy, ethnicity, that story. And those who understand the pivotal significance of this demographic for Rwanda's future will recognize immediately the contest of narratives. So I ask the question, in order for Rwanda to flourish, is a tectonic shift needed? A shift to a mutual commitment on the part of both current ruling party and the opposition, a commitment to their children to move from the divided struggle for satisfaction, revenge, justice, however they're construed, to the struggle for collective survival. Perhaps that old adage that earth is not a gift from our parents, it is a loan from our children, might apply here. We cannot, without serious consequence, conduct our proxy struggle through our children. So Hannah Arendt, in talking about this idea of natality, says something that's very profound. The miracle that saves the world, the realm of human affairs, from its normal, natural ruin is ultimately the fact of natality, in which the faculty of action, which he equates with speech, is ontologically rooted. It is, in other words, the birth of new men, new women, and the new beginning, the action they are capable of by virtue of being born. Only the full experience of this capacity can bestow upon human affairs faith and hope. So, is it possible to shift the narrative that you pass on to your children? What is it like to tell those stories? And some of the videos that we saw this morning really address that question. How do you pass on what happened there? The second concept, real quickly, has to do with thinking. And this is the contrast to what Adolf Eichmann was accused of as being thoughtless. And I'll just read you a couple quotes about what she says regarding Adolf Eichmann. The chief flaw in his character was his almost total inability ever to look at anything from the other fellow's point of view. And the longer one listened to him, the more obvious it became that his inability to speak was closely connected with his inability to think from the standpoint of someone else. And so there's something about the live virus of identification in thought. We know that this happens in Rwanda. I have talked to people. But how you bring about a widespread national change in this way that's the challenge. But I think anything that we can do to encourage the choice making on the part of individuals toward that end is useful. Thank you.
Thank you, Dan. Finally, our last speaker of the panel, Nicole Fox.
Thank you so much for having me today. today I'm going to be talking about the memorials in Rwanda, especially looking at the functions, the purposes, and the challenges. So a little bit more of an overview of the memorials. So today I want to talk briefly just about the literature that got me interested in thinking about memorials, and then look at some of the functions, the purposes, and the challenges, and then what these have in terms of thinking about implications for the future. So I became interested in memorials as one mechanism which is utilized by states or communities to really create a sense of collective memory that they can draw on for years to come, in a way that communities can build solidarity among citizens and among community members. And the central argument around this literature is that the past is socially constructed, and that in order for the past to be remembered, it has to be narrated. And narration is a process of getting these different aspects of the past and making them recognizable for people to digest and to interpret. And so memorials really help to facilitate this narration process. And they order memories and they order trauma in a way that the recipients can then understand and digest it. So Rwanda did this after the genocide. And for those of you who have been to Rwanda, it's hard to go anywhere without seeing some type of memorial. And currently there's 300 memorials and the size of a country about the size of Maryland. And there's 7 national memorials, and these memorials vary quite significantly. Some having a wall of names of all of the people who died there. Some are churches, some are schools, some are just a small little sign. Some are hospitals, plaques, here we go, former churches. And they differ significantly not just in their physical makeup and the choices they make, whether to include remains that people can see or have mass graves, but they also differ significantly in their orientation. So for example, some memorials are more oriented towards commemoration, while others are more oriented towards education or reconciliation. So in addition to having these physical spaces of memorials, there's also commemorations. And these have significant variation as well. And commemorations are usually held during the mourning months beginning in April. And these also vary in terms of the size, having a walk to remember, candle vigils, and some of these have up to 5,000 people that come in attendance. They also sometimes have burials of remains that were discovered the previous years. So I was interested in how do survivors understand these spaces? So in removing all the sociological jargon, why do these matter? So why are these important to survivors? And so I asked survivors, what do these memorials do in your life? What do they mean to you? And how do you use these spaces? And while I don't have time to go over all of these functions or the purposes, today I'll just be going over the first couple. I'd be happy to talk about them in more detail in the question and answer. So memorial functions were really described as these physical things that memorials do for survivors. So burial sites, places to honor mourn loved ones, keepers of evidence, social networking sites, education centers, and places that provide resources. So in thinking about them as burial sites, prior to the magnitude and the multitude of ways memorials function in present-day Rwanda, in the beginning, they really were also used to house bodily remains. So a lot of the survivors that I talked about shared these stories about how after the genocide, there were remains everywhere. And there needed to be a process of burying loved ones and doing so in a safe, healthy, and respectful way. And so participants really reflected on the challenges of this process. For as a country, there weren't really the expertise needed to exhume all of these bodies. So some participants talked about how there were mass graves discovered weekly. And one survivor said, we just had to begin lifting the bodies out, identifying them, and cleaning them so we could properly bury them, end quote. And they also became, and as you can imagine, in housing remains, places to grieve. And so survivors who lost loved ones and had loved ones buried at these memorials, they became places where they could bring flowers or say a prayer, and also speak and talk to their parents, and be a way that they can honor who their parents and their loved ones were. But in addition to housing bodily remains, they also house evidence. And they house a varying amount of evidence. So some sites provide a pretty significant array of evidence, like Damas mentioned earlier with the Kigali Memorial Site, and some have very little. And it's important to recognize, too, the amount of evidence and the evidence that is present shapes the stories that people hear about genocide, right? So at one memorial, you can see the blood that's left on the wall from where infants were thrown against the wall, and you leave that memorial feeling such horrific distress at the brutality that people experience and witness during genocide. And at another site, the evidence is that you're walking on the ground of UN abandonment, right? And so you're feeling anger in that response of the UN. So shifting gears a little bit to the more symbolic and ideological purposes of memorials, the central idea around memorials that survivors said in terms of thinking about what they really mean to them is remembrance, right? And there's really two different kind of ways of remembering, these more macro and more micro forms of remembrance. And so this was remembering history and then also remembering individuals. So you don't actually have to read the middle part of this large conceptual map, but the main thing about this map that I want you to come away from is that people started with remembering and ended with that remembering was a form of prevention and an investment in future generations and a future of the nation. And so what was interesting here is the trajectories of going from why remembering mattered and how remembering was implemented. They differed from site to site, depending on a site's orientation, if it was more oriented towards reconciliation or education or commemoration. But where they ended up was similar for many survivors. And while it was really beyond the scope of this project to really analyze whether or not these memorials did in fact change the future, what I think is important is that there was a belief that they did. And that belief provided a significant amount of hope for survivors, especially for survivors who lost so much. So I'm sorry to rush through this. I'd be happy to answer more questions later, but I do want to touch on some of the challenges. And again, I'm only going to be able to have time to talk about the first two, but I could answer more. One of the significant challenges that especially memorial guides spoke to me about was the challenges of remembering gender-based violence. So some memorials chose not to have this in their memorial at all, and that was upsetting for some of the survivors that I spoke with who were sexual assault survivors. So they felt like they were left out of these narratives, and that mattered for a variety of reasons. So one is they felt like they were left out of the story. But two, those who were remembered in this story also were remembered with resources and honor and all of these other aspects of collective memory that they felt they were left out of. However, memorial guides who did include gender-based violence in this narrative of the Rwandan genocide also spoke about the techniques that they used to try to remember gender-based violence in the face of not having physical testimony at times because of the context of stigma and shame of sexual violence. And so in this case, they used evidence or social programs, or these different aspects of both the physicality or the internal structure of memorials as launching points to discuss gender-based violence. So a quick example is This one has a coffin dedicated to a woman who was raped at this particular site. And by having this coffin in such a prominent place in the memorial, it was a launching pad to be able to talk about some of these difficult issues. So the second challenge that I'm going to be talking about today is the challenge of trauma. So NPR did a really interesting story on trauma. I don't know if anyone heard about it, but anyone who's been to a commemoration knows that trauma, both secondary and aspects of PTSD, although it's not really the same thing, is very prominent in commemorations. And so commemoration staff really tried to find ways to minimize trauma, both for public health and safety reasons, but also so that people could attend these memorials without getting secondary trauma because it's so contagious. However, one of the challenges of doing that was to avoid testimony that might incite trauma, right? And so what that meant was limiting some of these testimonies of women, especially poor women, sexual assault survivors, or people who were not doing very well after the genocide because they weren't able to give hopeful testimonies. And so this was a challenge in that, in some ways, this stratified collective memory in a way that those who had access to power or resources were the ones that were able to give more testimony. So this was something that people were really trying to, that different stakeholders within commemorations were really trying to find out what would be best for the country and for the health of the people. So finally, in thinking about the implications of this research, it's helpful to think of memorials and commemorations as these organizers of memory and organizers of trauma. And they make it organized in the way that they allow disorderly violence to be orderly in a way that it has kind of a beginning, middle, and end. And this process of organizing memories has an effect on survivors, both ones that can be really empowering and also that can be stratifying. And so the functions and the purposes and challenges of memorials matter in this larger picture because often how a society remembers its past structures its future. And it also shapes the future because it shapes social understandings of gender, and it shapes social understandings of public health and trauma, which has an effect on broader societal dynamics and also of the allocation of different resources. So I'd be happy to talk more, but I think my time's up, so thank you very much.
Thank you, Nicole, and thank you all for this very illuminating, thoughtful presentations. Now we have some time for questions and answers, for comments from the audience, and I have several very interesting questions here. I'll try to group and read if I understand the handwriting. But let us start with the questions that the first presentations on justice raised. For instance, we have a question here that asks, is there a sense in Rwanda, in the aftermath of Gacaca, ICTR, that justice for the genocide has been achieved? How would we know that this sense of justice has been achieved? And another question connected to that. Have ICTR and Gacaca courts been successful? Some reports on the current Rwanda say that there's a threat of more violence in Rwanda, that this threat is very real. What will happen in the post-Kagame era? So I'd like to raise these questions from our audience to any of our panelists. Yes.
I have just a very brief comment that justice isn't ideal, and that I think having a healthy frame of reference when we examine the practices in Rwanda is especially useful. The justice in Rwanda, justice in Hennepin County, Minneapolis, is something we aspire to, but rarely reach. And I think as Dan suggested, the act of attempting to do justice has great meaning for individuals and for broader social groups. I'll leave the other questions to the other panelists.
Maybe I'm probably, since the ICTR was involved in the question, I should comment. I mean, I don't. My response is I don't know. I can't pretend to know whether Rwandans feel that there's a sense of justice. I have some ideas. After something as horrific as the Rwandan genocide, I don't know that there's ever going to be a complete satisfactory feeling that justice has been done. I guess the question is there enough? I mean, it may not be ideal. Is there enough? And the real question with regard to whether there's enough justice is whether there's going to be a repeat. I mean, that's what it comes down to, and that's how I ended my presentation. I don't know. Like I said, the jury is out on that. My concerns, and I mentioned this, is that I don't think that there's been a sense among certain parts of the Rwandan citizenry that there's been enough done with respect to allegations of RPF atrocities. And I don't know how that's going to play out. I will say that I don't think it's of the same level as the genocide against the Tutsis. It's different. That doesn't mean it shouldn't be prosecuted. It should. And I think that the Rwandans, to some extent, are playing with fire if it's not handled vigorously enough. And I'd really like to see, obviously, that Rwandans can get through this and that ultimately something will be done. But I just don't know. And then I think there was a question: what's going to happen after President Kagame? And that goes back to the same question. And I think that raises a larger question, which this panel really hasn't dealt with, but I'll bring it up. And that is, to what degree can a post-genocidal society transition toward democracy in a healthy and effective way? And what might the time frame for that be? Right. I don't know. I think that has to be studied. I think that is in the realm, certainly, of scholarship that should be confronted directly. But I can tell you that those who would be incredibly critical of the current regime in Rwanda for having democratic deficits should probably realize that, by all rights, Rwanda should be a basket case right now. It should be one of the most dysfunctional, sad societies that you could find 20 years after the absolutely horrendous violence that was inflicted in that country. I don't think it is. I think it's actually amazing that it's running as effectively as it has been. But that has come at a cost, to a certain extent, with respect to democracy. So at what point, there's a sliding scale, right? At what point do you start to instill more democracy into the system at the expense of possibly losing some of the cohesiveness and order that's necessary to keep society functioning effectively in the wake of a genocide as horrific as what happened in 1994? That is a very difficult question, and if anybody in here thinks that there are easy answers, I challenge you to tell me what they are. I don't think you can.
Holly will try.
No, Please. Yeah, yes, no. No, I just have a few other comments, really in particular to our talk on the Gacaca. And we talked about one aspect of the Gacaca, which is the sanctions, but certainly an important aspect is also participants' views of the Gacaca. And this is something, admittedly, that Chris and I have not gotten into very much. I should say right off the bat, my own research is mostly on the violence itself and on patterns in the violence. There have been other studies on the Gacaca, and they really range in participants' views of the courts. The government did conduct a large-scale study on people's views, very positive views overall. There have been other scholars who have conducted their own research who have found more negative views, and that's something blatantly that needs more research engaging with the participants on their views of the process, if they believe that justice was served. So if there are students in here looking for dissertation topics or other future research ideas, that's one that really needs to be, there needs to be much more research on that. I'll also just add before turning it to panelists over here that in my interviews, I conducted interviews more about the violence, but at the end I did ask people their opinions on ICTR, on Gacaca, on different methods of transitional justice. And in the 45 interviews I conducted, there were very positive views overall, but again, that's just 45 people in a specific context. So that's what I have to add on that, and I'll let it to my other panelists.
I mean, if there's a gap, I'll just say briefly, I think it is miraculous that you had so many prisoners, so many people crowding the jails in Rwanda after the genocide, that they were able to do something to clear the prisons and provide some sort of justice and some sort of local reconciliation. The problem is, essentially, they were retrofitting a traditional justice mechanism that was meant to deal with petty crimes to deal with something like genocide, and that is clearly not going to be a perfect fit. Again, it's not whether the justice was perfect or even really even that good, but whether it was good enough. And I think Gacaca is a fairly amazing thing. You know, there are a lot of critics of the regime right now, but the regime always tries to do what it can, I think, to move forward. It may not always be the best thing, but it doesn't sit around paralyzed, you know, wondering whether it's going to please this critic or that critic. It tries to just get stuff done, and I think it's to be commended for that.
There are two specific questions for Chris and Holly on the Gacaca courts. Where did the idea to use Gacaca courts come from, domestic or international pressure? And there's another question, are there prosecutions for male sex violence in the Gacaca courts, and were there any sentences for that?
All right. I'm just writing these down. So for the idea, to be honest, I've heard varying accounts of where the idea came from. So actually, our colleagues from Rwanda might be the best ones to answer this. My understanding from, actually, Damas, if you would like to go ahead, I should say Dr. Gasanabo works with us on this project. He was not part of the presentation because he gave his own. But if you would like to answer this one, by all means, otherwise. As you're bringing the microphone, I can say from most scholarly writings on where the idea came from, really do see that the idea came from within Rwanda, and scholarly writings emphasize that there was a long period of time in which Rwandan leaders were trying to debate what they should be doing, and there was actually pressure. There was thoughts of a truth commission, there was different ideas, and it came throughout a period of debate, but most emphasize that the idea came from within Rwanda. If Dr. Gasanabo wants to add to this.
After the 1994 genocide against the Tutsi, many people were in prison. That was the fact, the reality. Then the question was, what to do with those people, knowing that there is no lawyer, there is no judges. So what to do with those people? Who committed the genocide? And the Rwandan government decided to reintroduce the Gacaca traditional court. As the panelists said, those people were not educated as lawyers, but knowing the context, the government decided to reintroduce the Gacaca court to help Rwandans first to say the truth, to try to know the truth, and also to make it fast, and also to bring kind of reconciliation among Rwandans. And I think we can criticize Gacaca, yes, but we have to recognize the results, knowing the context we are in. I think we have to consider the context, not thinking that we are in US. We are in Rwanda where everything is destroyed, where everything was destroyed. Gregory Gordon was in Kigali last week during the Kigali International Forum on Genocide. One of the panel was, what would you do if you were in a legislative assembly, MP or senator, in 1994 in Rwanda? What would you do? And the answer was, it was difficult to find the answer, because what do you think is a priority? Security, education, health, justice?
It's overwhelming.
Then you choose.
It's overwhelming. I mean, that's what the panel revealed, and they made the best decisions they could at the time. It's easy to be sort of an armchair quarterback now and look at them, in retrospect. There were mistakes and there were problems, but my God, what a difficult enterprise to undertake.
Yeah, I'd just add very briefly that we've heard conflicting accounts, we've read conflicting accounts about origins, and sometimes but it is a question of scale and a pragmatic solution. In the United States, we worry a lot about assembly line justice, but really this practice did function in many ways, and it's sort of a cheap quantitative trick. But if you we heard about the ICTR, and the ICTR had some amazing accomplishments, but if at that pace, it would take 653,000 years to have tried those 1.96 million cases. So this is as I say, the justice imperative to do something, to do good enough justice.
Yeah, exactly. I mean, the ICTR wasn't set up to do that. Again,
right. Very right.
Completely different scale.
If I can add one other thing, because there was a part two to that question that we didn't get to answer, and I'll just really briefly answer it. I believe it was about gender-based violence or sexualized violence. The three categories, again, category one included rape and sexual torture. Unfortunately, at this moment, we really only know whether a case was in a certain category, so we, to this point, do not have a lot of information beyond that. And just to say, when people talk about genocide or other forms of mass violence, often they have a very narrow view of gender-based violence or sexualized violence as rape. But really there's a very wide range of crimes that fall in that, and crimes against both females and males. So as we move forward, this is hopefully one thing we can look at in more detail in these records, how these crimes were factored into Gacaca, where they fell. But for now, all we can say is that category one was rape and sexual torture as the law stipulated, and we'll look forward to learning more about how different types of violence and gender-based violence were viewed and where they fit.
We have two more excellent questions on memory, and we have only 5 minutes, so I will ask you to be brief in the responses. One question is, what is the role of the rescuer or the dissident in mass atrocity remembrance? Mm-hmm. Is there a way to incorporate positive individual responsibility into prevention strategies? And I'll read another question that is also related to remembrance and the how of remembrance, which is a question directed to Daniel Wilderson. What stories need to be told to children to provide a mutual commitment to a collective struggle? Maybe you want to start, Dan?
Well, here's a textbook, Primary Social Studies, that I purchased from Macmillan in Kigali. And they have here, this is a level 6 social studies book, and they've got exercises that you can do. They have a basic synopsis of what happened. But one of the things that we've learned from Holocaust education is that there is something that's significantly transformative in hearing survivor testimonies. And right now, the number of Holocaust survivors is depleting, as you know. There was a gentleman who lived in Sacramento, I believe, or it could have been Tucson. It was several years ago. John Davis, who he worked at a Jewish community center, and there were a number of Holocaust survivors there, and he got connected to a juvenile facility. And he actually started to develop a program where the survivors would go to the facility, and the young people would come around and they would hear the stories, and because of their interactions with these survivors, is something that was very transformative that happened for them. I believe that there is, even though it's hard to tell, and there are all the issues about the telling and the commodification of the stories, I still believe that right now that might be an educational strategy in Rwanda.
So while I don't have the time to really answer the question about rescuers and the detail that that deserves, there is one memorial that has a really unique reconciliation program that brings rescuers and their testimony, and they actually tell their testimony to both perpetrators and victims, and they do this in order to kind of let victims know that not everyone was a perpetrator, and then they talk with perpetrators about different choices that they could have made. And so this is thought of as a unique kind of idea or model for a reconciliation program, and having rescuers be this kind of middle person, if you can think of. But I think that Rwanda is making a really huge effort to collect these testimonies of rescuers, and they're really amazing. People did really heroic things during the genocide, and I think that's something that's important to remember.
Anybody else would like to add something?
I can just add something really, really quickly. It's interesting, these categories of victim, perpetrator, and rescue, and I know we're using these today a lot, and it's also important to just keep in mind that often these are very fluid categories, and I know Taylor mentioned this morning a little bit of the difficulty of defining who is a rescuer, and Leanne Fuji and a number of Rwanda scholars write about this for Rwanda, but for other mass violence too, where often someone may have saved a neighbor and then 2 weeks later participated in the violence. So these are categories that are used often, but they are more fluid than they imply, and I just wanted to note that.
Thank you. Well, we've run out of time, and this it's been a fascinating panel and learning experience for me too. I would like to thank you, and please join me in thanking this great panel.